Hi, Greg, you there? Hey, Farley.
Thank you very much for your patience. I'm going to convene the public hearing of the Government Oversight Committee for Thursday, February 13th, 2025, and go immediately into recess. Good morning. We are going to reconvene the public hearing for the Government Oversight Committee. It's Thursday, February 13th, 2005. And with that, I am going to call our first person giving testimony, Representative Sarah Kitt. If you could please introduce yourself and proceed and tell us which bill you are testifying on. Thank you very much.
Good morning, Senator Gadkar Wilcox and Representative Dathan and distinguished members of the Government Oversight Committee. I'm State Representative Sarah Kitt. I represent the 134th District, which includes parts of Fairfield and Trumbull. And thank you for the opportunity to provide testimony in support of Raised House Bill 6883, an act prohibiting the disclosure of certain residential addresses under the Freedom of Information Act and protecting the location of housing for domestic violence and sexual assault victims. In 2024, a report by the Connecticut's Department of Public Health Injury and Violence Surveillance found that in Connecticut during 2023, 359 minors and 546 adults were seen in area hospitals for injuries from sexual assault. As awful as these numbers are, they are only the tip of the iceberg. Nationwide, sexual violence is underreported due to fear, shame, and stigma. Often survivors of sexual assault need emergency, anonymous shelter to heal and pursue justice safely. While our current state statutes protect the addresses of domestic violence shelters from FOIA requests, that's not the case for sexual violence shelters. Section 2 of House Bill 6883 would expand these same protections to victims of sexual assault and sexual assault shelters. Additionally, the proposal will require that any public agency meetings that discuss the confidential housing described above be held in executive session to ensure that protected information is not publicly disclosed. This bill will save lives. I strongly urge the committee's favorable report on this bill, and I want to thank you for your time and consideration, and I'm happy to take any questions.
Thank you very much. Just one quick question for me. For the disclosure, you say housing. Are you referring to safe housing and or are you referring to the agencies in general?
This would apply just to the safe housing or any property that is rented to do confidential interviews, assessments, prepping for court appearances and such. So not the centers themselves. Those must remain public so victims can find them and be screened and receive services that they need.
Thank you very much. I understand that the current statute allows for safety. I think we heard that in the public informational session earlier. So I'm just kind of trying to understand, is there situations where a forum of a town body would be discussing these in a public space?
It is possible that they could come in front of, say, a zoning and planning commission for approval for building a house or for having permission, certificate of occupancies. And in those cases, it would be dangerous to have those addresses in the public sphere.
So likewise, if there was like a fire or something, would you say that the proposed bill should cover those sort of residents if there's a fire and there's a report of the fire on a journalistic way, maybe a blog or a article for a newspaper? Would you suggest that the addresses be redacted in those situations as well?
I would suggest that as well.
Okay, great. Anyone else on the committee have any questions? Is there anyone on Zoom? It doesn't appear that anybody else has questions, so thank you very much for your testimony. Are you going to be submitting that in writing as well?
I did submit this on.
Wonderful. Yeah, our records aren't quite updated yet. So thank you so much for your testimony.
Well, thank you for your time and consideration.
Thank you. Next, I'm going to call in Russell Blair from the Freedom Information Commission. And thank you for your patience of going back and forth from the informational session. Just make sure you reintroduce yourself for the public hearing and let us know which bills you're testifying in favor of.
Good morning, Russell Blair from the Russell Blair, Director of Education and Communications at the Freedom of Information Commission. Going to be testifying on House Bill 6882, as well as House Bill 6883, Senate Bill 973, and Senate Bill 1209. So Representative Dathan, Senator Gecker Wilcox, Senator Sampson, Representative Carney, members of the Government Oversight Committee. Thank you for the opportunity to testify today. First, just going to speak very briefly on House Bill 6882, which is recommendations of the Freedom of Information Commission for revisions to the Freedom of Information Act. This is really kind of a cleanup technical bill. The most significant change included there is there's a provision in the law that allows someone to use a handheld scanner to scan copies of public records. It doesn't really explicitly allow for a smartphone because the law was written before we all had smartphones. So that change, the commission believes, is adopting modern technology, allow people to use smartphones to take photographs of public records if they wish to do it that way, to make their own copies. It doesn't make any changes to the fee structure. So cities and towns are allowed to charge a $20 fee for a handheld scanner. They could charge somebody $20 to take pictures with their phone, if they wanted to inspect a particularly large file. The rest of the changes are really mostly technical in nature. There's a part in there about how the FOI Commission is supposed to do training on vaping in public buildings, which I do not include as part of my normal presentation. So we're looking to get that changed. And there's a couple of definitions in there that we want to streamline. One of them is related to how FERPA, the terms that they use, and aligning our law with that. So we appreciate that concept being raised. That's on 6882. Next, I'm going to talk about Senate Bill 973, which is an act permitting redaction fees for the disclosure of records created by police body-worn recording equipment or dashboard cameras. This is a proposal that has been around for a couple of years now. We've worked with the Connecticut Police Chiefs Association on this language. We're happy to see that there's no new exemptions that are proposed. We believe the fee structure is reasonable. We do call attention to, though, there is one sort of technical conflict in the language. There is a provision, my understanding is that the intent is that if you are an involved party with the police, that you can get the footage of your own encounter with the police without being charged. So we would still have free access for people who are involved with the police. But there's some language there I think that needs to be cleaned up, because there's one reference to where they get it for free, and then another to where they would have to pay after a certain number of hours of work that is performed. When I do trainings in police departments, we hear a lot from municipalities about the burden of body camera footage and, the time and the energy and the effort and software that's gone into it. So I think the commission recognizes that, this is sort of a unique circumstance, and therefore maybe requires, a fee schedule that's a little bit different than other public records that are out there. So the last two bills that I want to touch on, the first one, just very briefly, Senate Bill 1209. The addresses, we talked about that a little bit in the informational forum, so I'm not going to, go ad nauseum on that. But I think, important for everyone to understand, I think the commission's main concern with this is, it's not the panacea that many people believe it to be. It does not cover all public records. And, we live, as we mentioned in the forum, we live in a different age than I think when those address exemptions were first proposed, really before information was widely available on the internet. So, you've got our written testimony on that. And then lastly, on House Bill 6883, Section 1 of that bill, again, deals with addresses, which we've talked a lot about. But I do want to just very briefly talk about Section 2, which deals with the issue of information that indicates the location of a shelter or transitional housing for victims of domestic violence. To the extent that Section 2 expands the protection that exists for locations of shelters or transitional housing for victims of sexual assault, we don't have any objection to making it clear that whether it's domestic violence or sexual assault, the information about those locations is protected from disclosure. We do understand the intent of the proposal as it applies to meetings of boards and commissions, but we do have concern there. For one example, land use boards, if somebody were to propose to develop this type of housing in a community, we would now have an unusual circumstance where you would have a zoning application that would be considered in executive session, where the public would not have the ability to hear those discussions. Notwithstanding that, there's also other statutes that require public hearings on certain sort of site plan applications. If somebody wants to build housing in a town, they have to file a site plan. There's a public hearing, there's notice of the public hearing that goes in the newspaper. That's just one example of where a board, by other statutes would necessarily maybe have to discuss some of this in a public session. We suggest either modifying the language to remove the piece as it pertains to meetings, or in the alternative, maybe there's a way to provide discretion to the agency to make that determination. We did a little bit of a review before the public hearing. We only found, I think there's a couple other instances where there's other laws that deal with executive session. Most of, executive session reasons are very specific in the Freedom of Information Act. So this would be a deviation from that. There is one board at the Department of Motor Vehicles that deals with, I believe it's drivers who had medical issues and had their license suspended. There's an appeal process. That board is granted confidentiality for some of its work. And boards of ethics have a process where they have a little bit of confidentiality, but only in the beginning of their process. Those are really the only two examples of where you have a law requiring certain discussions to be held in executive session. And the last thing I'll note too is that the law does allow, if records are protected from disclosure, so if there are records that would not be disclosed under FOI, a board can also go into executive session to review those specific records. So if there was an instance where something came up, maybe there was an employee who had an issue and it was a personnel matter to be discussed in executive session, and part of it dealt with one of these addresses, you could go into an executive session to discuss that because it pertains to a personnel matter, or if it pertains to records that are otherwise protected from disclosure. So I think there's a couple of ways existing that some of this could be done in an executive session if necessary, or alternatively, we would suggest maybe a way to narrow that, because I think there are times when it would be necessary, to at least identify the address. Maybe they don't have to necessarily get into all the details of what happens there, but addresses at some point, with land use boards in particular, have to be publicly disclosed as they, talk about a project and what's going to be developed, and the neighbors maybe want to have an opportunity to discuss that proposal. So that's my testimony, and I'm happy to take any questions from anyone on the committee.
Thank you very much for your testimony and also the informational hearing that you gave earlier. Just a couple follow-up questions on House Bill 6883. You were concerned about some of the, P&Z or site planning of maybe a potential safe house or something, so that, the public would know that something is coming. Generally, my understanding is when you're in the planning stages, you wouldn't identify any person's name. It would only be in theory that a organization would be setting up a safe house in the area. Would we be able to maybe limit the discussion in public forum of what type of housing, or if it's supportive, or housing for individuals who are affected by crime? like domestic violence or sexual assault, would we be able to exclude that information from the public forum, but be able to include it in an executive session so that when the matter would be heard in a public forum for, the P and Z or the site plans, that would be known that it was a congregate housing of some sort, but not exactly commit to what type of congregate housing it is.
It may be possible. Part of the challenge, I think, you're right, is that, not necessarily everything is going to be shared at a, planning and zoning, commission meeting about, what ultimately is going to happen with the property. But the other challenge with planning and zoning in particular is that, you have a lot of different people that have a lot of, different vested interests. You've got the developer of the project, you've got the members of the Planning and Zoning Commission, you've got the members of the community, you've got abutters, neighboring properties, who all have different, rights to notification of when something's going to be built, and they have opportunities to discuss at public hearings. So, perhaps there's a way to narrow it a little bit further. Or, again, maybe, I don't know if there's a way in the existing process, I'm not super familiar with this, but, if somebody is proposing, one of these facilities, if you're going to build a duplex, I don't know that you have to tell planning and zoning, oh, this duplex is going to be for the purposes of housing people who are victims of domestic violence, right? You have to get a permit to build the duplex. So I think some of this maybe, is dependent upon, what the requirements are of the Planning and Zoning Commission, or also, what does the developer have to speak about publicly, and that, I'm just not familiar with exactly how all that happens. But if, maybe there's a way where, they can propose what the building is, and they don't have to say, what the ultimate use is. But I also don't know, local cities and towns might have, ordinances or regulations that deal with congregate housing, and, there might be, they might have to get a variance or something, or they might have to get a special permit. So, I think in particular with land use, I just think that there's some questions there. Maybe there's better language, or, there would have to be an examination of the process there and sort of seeing what is typically disclosed.
Okay, great. That's helpful. I think that's something that we might need to follow up on. But I appreciate that. One other question, the statute talks about the exemption for domestic violence. This is including sexual violence. What about other sort of crimes that might happen to an individual in which it may not fall into that domestic matter? Is there any sort of exclusions for victims of crime from getting their addresses disclosed?
Do you mean like relative to this type of housing, or just more broadly?
More broadly. So in terms of there's a victim of crime and there is a criminal investigation and so on and so forth, would a member of the public be able to FOIA either police records to find out the address of the victim?
So with police records, there is an existing exemption that deals with names and identifying information of victims. So with police reports, routinely victim information is withheld from police reports. So there is an exemption dealing with law enforcement records existing already in terms of identifying information about victims.
Okay, that's helpful. One other question. I know we talked earlier, and this is kind of more of a broad question, but we talked about safety and security exemption, kind of more broadly. We have, as you know, Connecticut has passed the Trust Act, which basically protects undocumented people from being sort of targeted and I guess it's more of a how a police might get involved with somebody who is undocumented. In terms of any other public records of people's immigration status, would an individual be able, or ICE, for example, be able to discover addresses under the FOIA Act outside of police records and school records?
So depending on, what the record is, there are a lot of records that are available that would have addresses, on them. There's not a broad exemption for everybody's address, that if it's on a public record. If somebody, has an issue in their town, and they come to a public meeting, a lot of public meetings, and they're allowed to do this, they require people to state their name and address when they speak at a public meeting. So, there's not a broad exemption for addresses widely in FOIA. There are certain cases like we've talked about with 1217, information about victims and police reports. This deals with addresses of certain housing. So, there are times when that information can be withheld, but there's not a broad exemption for, everybody's home address on every record.
Okay, that's very helpful to know. In terms of our exemptions for our FOIA, do we have exemptions that are greater than other sort of exemptions of our federal FOIA laws?
I wouldn't necessarily say if it's greater or less. I mean, they're kind of different. One important thing to note is that while, the federal FOIA exemptions are different, and, federal FOIA does not govern our process is governed by federal law. So what that means is if there are federal programs or federal laws that require confidentiality of certain records, and those records are given to state agencies, then they are still confidential under the Connecticut FOIA. So one example I can give you where this comes up is, things dealing with Medicaid or Medicare. They interact a lot with the Department of Public Health. Sometimes there's investigations and things that are done in nursing homes, and because those are funded through the federal government, there's federal laws that come into play. And so what that means is somebody may request information from the Connecticut Department of Public Health, but there might be federal protections, and some of that information does not get disclosed. So the federal FOIA, the exemptions are different, and there is, there's some more things in there, a little bit dealing with PII. They also have a different response timeline than Connecticut law. So, it's a little bit different, but they do cover a lot of the same categories. And also, if there's a particular federal program that requires confidentiality, like another example, HUD has a lot of laws and rules about confidentiality of tenant information. A housing authority in Connecticut is a public agency, but if I FOI a Connecticut housing authority, they cannot disclose certain information because of what HUD tells them to do. So there is a lot of federal laws, not just the federal FOI, but it's probably more often other federal laws or rules or regulations that do have a bearing on what can be disclosed in Connecticut.
Okay, that's very helpful. Do any committee members? Oh, we have our vice chair, Representative Gucker.
Good afternoon, and I'm terribly sorry I missed your presentation earlier. I was sitting on I-84 for like 2 hours, so
I'm sorry.
Terribly sorry about that. One of the things you brought up is very close to my heart. I've done a lot of, there's a lot of echo in here. I've done a lot with dealing with P&D, planning and development, and other forms. I can also tell you that a lot of times when these projects do come up, they are listed for most times variances needing to change use. And that's where we come into this rub to where we may be taking something, for example, a single family zone, and want to turn it into multifamily or multi-use or congregate housing. That's when I would like to hear more clarity. How do we navigate keeping that information in a safe form, but at the same time, the public has the right to know what's being built in their community. Planning and development needs to understand what the impact is going to be, whether it's going to be impact on the infrastructure, whether it be traffic, whether it be sewer use, water use, things of that sort. And then, of course, variances as far as setbacks.
So, on that, I would say, again, I think that highlights the importance of why, some of this has to be discussed in public, but I would, my suggestion would be, is there a way, and again, I'm not, as schooled on planning and development, to say for certain, but, my mind goes to, what's before the planning and zoning is what are you going to build? How many people are going to live there? How many units are there? How many cars? How many parking spots? It's not about who is there, right? I don't know that there's a requirement that you have to tell the Planning and Zoning Commission, we're building a 4-unit complex, and oh, by the way, these are the people that are going to live there. If there's a town where they require a special kind of permit or something for congregate housing, that gets a little bit harder. But my understanding would be, is there a way that the developer could, propose the project, go through all the public channels, and the neighbors know, okay, it's a 4-unit dwelling, but they don't know that those 4 people are going to be, victims of domestic violence. I would seem to think there would be a way you could do it without having to share all that, but I'll confess that, I'm not intimately involved with it, so I don't know, maybe there isn't, but my suggestion would be try to go through the public process without identifying, who ultimately is going to live there, because that wouldn't seem to have a bearing on whether or not, the development is appropriate or not, right? They're concerned about density, about how many people, traffic, those sort of things, not the people that are going to be there.
Thank you very much. Representative Gucker.
Thank you, Madam Chair. And if I could follow up, you are correct. It's mostly about the. I don't have anything on. Is that better? Yeah. I was hearing an echo before. That's why I was wondering. Back to my train of thought here. You're absolutely right. But a lot of times, like we've dealt with, I do have a shelter in my community. That is it was identified when it was being built, that it would be a women's shelter. I would say that the public came out in support of it because they understood what it was going to be, but they're not going to say who's going to be in there, so I kind of agree on that. I think we're running a delicate balance here on what would be the public's right to know what's happening in their own community, but at the same time, I'm fully sympathetic to protecting those who will be utilizing those services. And I will say there are many times where we run into a little bit of, I don't want to call it racism, but I want to call it, people not at NIMBY, not in my backyard. I don't want that in my backyard. So if you could give some thought as to what would be the best language to be able to, one, be able to give the public the right to know what's being built in their community, so that they have an equal say in it, because they're the ones that ultimately, once these projects are done, are the ones that are living in these communities. But then two, also be able to protect those who will be utilizing those services. So I would look forward to any kind of, help you may have in that area too, because it is kind of like threading the needle from 5,000 feet. It's a really tough thing. I understand both sides of it. So those are my concerns. Thank you.
Thank you very much. Mr. Russell, do you want to respond to that or?
No, happy to follow up on any discussions, about how to address that. Because again, I do, we do understand the concern, and the existing exemption, and we understand the reason for that. But I think expanding it to public meetings is a little bit different, and trying to navigate that process, as it's a little bit unusual. A lot of exemptions deal with records. We're very familiar with those. There are far fewer that dictate, what boards and commissions can talk about in public meetings. That's a lot, fewer instances where boards can go into executive session. So this would be a little bit more unusual, but we're happy to try to address some of the concerns.
Thank you very much. Seeing no other questions. Thank you very much, Mr. Russell, Mr. Blair, for your testimony today. It's really helpful in your extensive presentation, which we are going to keep on our committee website. I think it's really helpful. And it is, I think many members of the General Assembly would love to take you up on the offer to come to their communities, to share your wealth of knowledge with everyone. Thank you so much.
Thank you.
Next, we have Travis Woodward, who is on the Zoom.
Thank you for having me.
You You could introduce yourself, and just to let you know, you have 3 minutes.
Absolutely. Representative Dathan, Representative Carney, Senator Lopes, and members of the GAE committee. My name's Travis Woodward. I'm a resident of Hamden. I'm an engineer for Connecticut Department of Transportation. I'm also president of CSEA SIU Local 2001, a labor union representing 25,000 state, municipal, Board of Ed, active and retired public and private sector workers. I offer the following testimony on behalf of CSEA for Senate Bill 1209. And my full written testimony has been submitted. I might abridge it here just for the sake of time. CSEA represents public employees throughout Connecticut, including paraeducators working for local school districts, people working in municipal public works departments, environmental analysts working for the Department of Energy and Environmental Protection, and more. This legislation is a start, but the prohibition of disclosing residential addresses should not be restricted to just teachers. At the very least, the home addresses of paraeducators, school nurses, custodians, cafeteria workers, and all school district workers should be prohibited from release. Ideally, however, this prohibition should apply to all public workers. Public employees do critical work for the people of Connecticut. I would never want that work to put any of us, our families, or our coworkers at risk because someone abused the FOIA process. Even our DOT engineers are at risk of harassment. Once while rehabilitating a portion of highway in Fairfield County, a coworker of mine was verbally accosted near the project by a resident who was unhappy about construction noise. This was not someone blowing off steam and then going about their day. This was a person who could reasonably be believed to want to take violent action against my coworker. Thankfully, in this specific case, the situation de-escalated, but my coworkers and I still think about what could have happened. Right now, there's nothing to stop this individual from using the Freedom of Information process to find my coworker's address and seek revenge at their residence. State, municipal, and Board of Ed workers want to be added to the list of people whose residential address is blocked from release through the FOIA process. Currently, there are people in 13 groups whose residential address is exempted. These groups include police officers, firefighters, employees of the Department of Children and Families, members or employees of the Commission of Human Rights and Opportunities, and other people doing important work on behalf of residents of Connecticut. The safety and security concerns that lead to these groups being exempted are also held by people working for the state, municipalities, and boards of ed. We are not asking for special treatment or trying to hide from accountability, but like other people whose addresses are exempted from release, we just want to keep ourselves and our families safe. Prohibiting the disclosure of residential addresses of public employees through the FOIA process will not harm state, local, Board of Ed operations, or the ability of the public to hold the government accountable. It will, however, help protect the people who work tirelessly to make Connecticut a wonderful place to live and raise our children. Thank you for hearing my testimony.
You are a professional here, Mr. Woodward, but just to correct you, we are the GO committee, Government Oversight.
GO committee.
Yeah. Yes, but
Yeah.
you came in 8 seconds under the time, so well done. Anybody on the committee have any questions for Mr. Woodward? Seeing none. Thank you so much for your testimony today.
Thanks again.
Next, we have on the list Ms. Korea Brown. Are you? She's supposed to be in person. We'll come back to her. Next, Michelle Jacqueline. She's also in person. Oh, here she comes. If you can please identify yourself and note that you have 3 minutes.
Good morning, Senator Wilcox, Representative Dathan, and honorable members of the Committee on Government Oversight. My name is Michelle Jacqueline, and I am co-president of the Connecticut Council on Freedom of Information. We are a 70-year-old organization comprised of Connecticut news media outlets and First Amendment supporters. Members of CCFOI's board have submitted written testimony on SB 1209 and SB 973. I would encourage you to read their statements. But I'm here today to comment on HB 6883 and HB 6882. And I would just mention that Russell Blair has very ably addressed these two bills. So I am going to digress from my written testimony and just make a few brief comments and try and come under the 3 minutes. So CCFOI opposes Section 1 of HB 6883, which adds a specific group of attorneys to the list of already protected addresses. Almost every year, I, representing CCFOI, have opposed efforts to broaden the list of protected addresses. And Russell Blair talked about how you could Google all of your personal information. So I'd like to digress for a moment and talk about something called data breaches. My husband and I have been subjected to no fewer than 6 data breaches in the last 2 years. I have 4 accounts with a security monitoring company called Experian and 2 accounts with one called Kroll. In those security breaches, our personal information, including birth dates, social security numbers, addresses, medical information, financial information, have all been disclosed. And in one comical coincidence last year, I was here testifying on a bill that would have exempted the addresses of local elections workers, of which I am one because I work as an assistant registrar in my hometown. After I testified on that bill, I went home and opened my mail to find a letter from a health insurance company, which said that once again, my husband and I had been victimized by a data breach in which, you know, possibly a criminal gang had viewed our information. So to suggest that by exempting the addresses of certain classes of state employees, we are doing anything at all to protect them is providing them with a very false sense of security. We live in times of security risk. We are all at risk. No matter where we live, no matter what our occupation, we are at risk of, and that is just a reality that we have to deal with. I would also just address HB 6882, which we strongly support. It's a bill that has been introduced and reintroduced and approved by the GAE committee for several years, and yet that non-controversial bill has died on the calendar each year for reasons unknown. But I would just point you to Section 4 of that bill that would bring Connecticut into the 21st century by expanding the definition of handheld scanner to include mobile phones and cameras. It's just common sense, since nearly all adults nowadays have cell phones and or cameras. This change would make it much easier for citizens.
I'm going to ask you to.
Yes,
wrap
I
up
will
your
stop.
comments.
Okay,
Yep,
just-
thank you.
Yes, it would make it easier to copy public records, and it would free up local staff from having to make copies. It's a win-win proposition. And thank you for listening to my testimony, and I would be glad to answer any questions that you have.
Thank you very much. Our Vice Chair, Representative Gucker.
There you go. You got it. Thank you very much for testifying today. One of the things, you're absolutely right. We do live in a technological advanced world to where you can pretty much Google and find anything out there. But do you think that by taking some of these names out of FOI requests as far as the searches that it might limit it down? I mean, there's no absolutes in life. I mean, people are going to find you no matter what. Do you think by expanding FOI protections to individuals, it would really just narrow down some of those accusations or some of those people?
Ms. Jacqueline.
If I understand your question correctly, by expanding the group of special interest groups whose addresses are protected, we are doing nothing. We live in these dangerous times, and those addresses are so readily available that you're really doing nothing to protect people, whether it's transportation workers or teachers, you know, to give you one example, I was a political columnist for the Hartford Courant for 8 years, in which I wrote very controversial columns. And I received very hateful telephone calls and emails, some of which came very close to threatening me. Okay. And there was nothing I could really do about it. Could they have gotten my address and done something harmful to me and my family? Yes. Okay. But, I was just a citizen. I was a journalist. I had no protection. The Hartford Courant wouldn't give out my address, but certainly I knew that anybody could have gotten my address and done me harm. And that was quite a while ago. These are dangerous times we are living in, and none of us are really protected. And by not revealing somebody's address, what are we really doing? We're doing nothing. Because as I mentioned, my husband and I have been the victims of six data breaches in just 2 years, in which all of our personally identifiable information has been revealed. It's scary, but there's nothing we can do about it. I hope I've answered your question. I'm not.
Thank you. Representative Gucker.
No, I just want to thank you for that. I've also been where you are. I've had the death threats. I've had to get police protection. I've had to do things of that sort. I understand where you're coming from. I just wanted to pose that question out there, just thinking that, if there was a way that if it's not so readily available, I mean, let's face it, people are going to find you, with voter records and with Google and with Facebook and with even property records, they will find you. So I'm just kind of thinking more along the lines of, does this kind of knock that list down? I'm not saying you're going to be totally invisible, but would it kind of knock down some of the threats that may come your way or other things? That was basically what I was looking for. Thank you, Madam Chair.
Thank you, Representative. Thank you for your testimony today. It's really helpful. I know a lot of folks are in the same boat you have been with this data breach and some of the concerns, and we are living in a new age. So seeing no other questions here from the committee, thank you very much for your testimony. Next, we have James Murray, who is going to be remote, and I don't see him online yet. Mr. Clerk, is he online? Nope, we'll come back. Jocelyn Delancey, I see her online. Jocelyn.
Good afternoon. My name is Jocelyn Delancey. I am the Vice President of the Connecticut Education Association, representing over 40,000 educators in the state of Connecticut. I'm also a 5th grade teacher. I'm very excited to submit testimony today on behalf of SB 1209. We are, in the past, I would say multiple years, we've seen a rise in incivility towards our educators here in the state of Connecticut. It is become almost untenable in some situations when educators are harassed either online or in other forums for the work that they do with their students each and every day. And having our private information available through FOI is puts us at risk. And it actually hurts our ability to recruit and retain educators, because many of our teachers do not feel safe when they have that, when individuals have access to their private information. On top of that, we would like to also pursue ensuring that our personal cell phone numbers are also part of that protection. It is something that people who are upset use to go about a process that they actually have in our public schools to be able to submit complaints, reach out to administrators, and use the professional and kind forum of discussing issues that they have concern with. Instead, we see people using social media, harassing people through text messages, phone calls, letters, at some points even driving by their homes and threatening them for the work that they're doing to support students. So we would really support building more protections through the FOI process and ensuring that our educators are safe from hateful behaviors. Thank you.
Thank you very much. Does anyone on the committee have any questions? Seeing none, I am just going to double check that we have did you submit written testimony?
I did.
Okay, great. I just missed it on the system. I'll have a look. Okay, thank you. Thank you. Oh, Representative Carney, sorry, I missed you there.
That is okay. Thank you for your testimony. Just a couple of questions. So you indicated cell phone numbers. Is there a requirement for you or teachers to provide their cell phone numbers? I guess on any documentation that could be subject to freedom of information?
Yeah, so we actually have to submit our cell phone numbers a lot of times for two-factor authorization for a lot of different programs that we have and other spaces. So all of our personal, and for me personally, I don't have a home phone number. I only have a cell phone number. So that, of course, is what is documented with our records. So yes, we are required to have, some sort of personal private phone number that people then use the FOIA request process to access and then use oftentimes inappropriately.
Thank you.
Okay.
Representative-
And I guess the other question, and I guess this probably would not have to do with freedom of information, but are there any policies regarding, I guess maybe would be individual school district, what a teacher can or cannot post on social media? Because perhaps something like that could create an issue.
So, yeah, a lot of our schools have social media policies that require us to, be able to behave in certain ways and present certain ways. I'm not sure if you know that educators often have a limited freedom of speech when it comes to how they share their ideas and beliefs across a broad spectrum. And so what we're seeing, though, is that a parent, an outside stakeholder, another community partner who might be upset. I experienced this myself back during the pandemic when I was advocating for stricter health protections for my teachers, my colleagues, and our students. And I had parents posting things on Facebook, harassing me, calling me names, demanding that I leave the district. And so it happens often where people use social media accounts to just kind of berate educators. If you have a problem with an educator, there's a process. You can go to the Board of Education meetings. You can speak to your superintendents. You can speak to your administrators. There are lots of ways that we can deal with these problems. But what we're seeing is that people access teachers' personal information and then use that to intimidate and to harass and sometimes threaten in some instances. And we're just trying to protect that process. If I'm doing something as an educator in my class that isn't appropriate or that a parent is feeling they have issue with, there are processes to deal with that. I'm not sure why having my personal phone number, address, why those things should matter to the public. I'm not sure why that should be something that the public should have easy access to.
All right. Well, I appreciate that answer, and thank you very much. Thank you very much for everything you do and for coming and testifying.
Thank you very much, Representative Carney. I have my good co-chair, Senator Gadkot Wilcox.
Thank you so much. I'm in and out of meetings, so I apologize if this has been answered. Are you noticing a rise in these instances? And is there any data that we can find in schools? Does the CEA have data about, requests that are being put in so that we can see whether or not there's a trend, which I've heard anecdotally from a number of teachers. They feel more threatened and there's this sort of increased risk. I'm just wondering if there's anywhere we can get information on that. My understanding today from that we don't have a database at the state level, which I think actually would be helpful. But is there anything else that maybe the CEA has that we can sort of see what the trend looks like? And do you see a rise in these kinds of requests? Thank you.
So I guess we can use the FOI process to FOI the data from school districts about how many requests are coming in and ensure that we have that data to make sure that we can see how many requests each district is happening. And again, it varies by district. But if a district has a request, they are obligated to hand over our personal information. And that's not just from, people within that town. That could be, a newspaper media outlet. That could be a private company looking to do all sorts of different things. So, we certainly can get that data for you. It might not be quick.
Thank you.
Thank you very much. Any other members have comments, questions? Seeing none. Thank you very much for your testimony, and I hope you have a good day.
Thank you.
Next, we have Katie Dias. Oh, there she is on Zoom. Katie, please introduce yourself.
Good afternoon. I'm Kate Diaz. I'm the president of the Connecticut Education Association and a high school math teacher from Manchester, Connecticut. I come to you live from Washington, D.C. We stepped out of the Secretary of Education hearing because this was so important for us to talk to you all today about. As you've heard, we have more and more teachers who are feeling more and more vulnerable. And while I do appreciate the comments about data breaches being constant and pervasive, I'd also say that these laws are a statement of belief of what the state of Connecticut wants to support. And so we're looking at this from the perspective of how easy are we going to make our kind of access to educators. And we are not publicly elected officials. We're individuals who chose a path of our career to be public servants, which I think is important for us to distinguish. Educators, your third grade teacher is not necessarily signing up to be a public official in the way that elected officials are. So to create rules for us specifically that limit the access to our publicly facing addresses, places of employment, feel free to reach out to us at the schools that we work in. That's where we want to communicate with the greater population. We have no problem with that access. It's when we cross the line into the personal, where you make not just myself, but my family and the people I love vulnerable. That's where the problems live. And to be perfectly honest, 20 years ago, we might have had a different conversation, but we do live in a world that is increasingly aggressive towards our public servants, towards our public educators. And to set up ourselves as a state that wants to protect those individuals, I think is the right thing to do. It's the place the state of Connecticut wants to be in. It's the statement we should be making. So we really are imploring you to add educators' private information to the list of things that cannot be FOI'd by any random individual. And as the president of CEA, I often get offers to sell me, my members' information. So this information is being culled by organizations who are actually trying to sell it back to me. The absurdity of that should be problematic for everybody in government. The knowledge that happens, the idea that we get blanket FOI requests that people want us to turn around and send Excel spreadsheets of all of the educators in a district, and just they could organize them and make it nice and neat and tidy so we know exactly what to do. So this problem is much greater than I wish it were. Honestly, I wish this wasn't a problem. But it's just the world we live in. And so it's important that we put protections in that let our educators know that we're supporting them. We recognize their vulnerabilities, and we're going to do everything in our power to keep them safe. And that's what I'm asking all of you to stand with me to do today in passing this bill, quite frankly. I hope we see it move forward and that I have the opportunity to lobby you quite aggressively in the future on it.
Thank you very much, Katie, for your testimony and jumping out of your meeting in DC. I know it's important to have you as an advocate for all teachers in Connecticut, especially at this critical time. We have my good vice chair.
Thank you, Madam Chair, and thank you for your testimony. One of the earlier people who testified was stating that they didn't feel providing these protections would do much because of access to the internet, access to Google, access to other methods, data breaches, etc. I'm going to pose the same question to you that I posed to her. Do you feel that adding these protections would maybe limit some of the harassment or some of the requests? In other words, if your information was not available in this manner, it might cull down some of that, some of that aggression you're seeing?
Well, we certainly do. We feel strongly that when we seek to protect the educator's information, we at least put up another barrier to getting this access. Ease of access causes a lot of the drama that we see, right? The idea that you can just quickly go get and it has to be turned over really empowers the people who want to use this information in ways that we would say are really not desirable. And so for us, creating at least a challenge to finding that information. I'll also tell you, educators are fairly savvy and we know how to protect ourselves online as much as possible. We've known, I don't think I've known a single educator who hasn't had an unlisted phone number their entire career. So we've been ahead of the curve as frequently as we could to make and protect our privacy. And I think that is one of the things that we're really just asking for is that the government be our partner in protecting us. And we get it's an imperfect world. We understand that vulnerabilities will exist beyond what we can all control. But at least within the world of the things we can control, let's control it.
Thank you very much. Representative Gucker.
No, I just wanted to thank you for that answer. And I do feel the way you do. I believe that if we can add more barriers, it would, when we talk about crime, they talk about crime of opportunity. And I would think in this particular case, by maybe affording some of these protections, it might knock down some of that happening for you. So thank you for all you do, and good luck in Washington. Let's get some good stuff down there.
Thank you very much.
Thank you.
I think we have one other one. I could co-chair.
Thank you, Kate. Thank you for being here, taking the time to step out for this and providing your testimony. Very much appreciate it. And your statement that, we should be doing more to protect our teachers. Our teachers are there to inspire our students, and you're already doing so much in the classroom and facing other hurdles and really, providing those protections and making sure what we're doing to support teachers is so critically important. I just wanted to ask you, I know one of the things we heard from the FOIA Commission is this is the idea that there's already a safety and security, exemption or opportunity to request an exemption from the FOIA process for that. And, if you can provide your response or testimony to whether that's insufficient or, why is it beyond that process? This protection separately as a category for teachers may nevertheless be necessary. Thank you.
Well, I would say the difference is being proactive versus reactive. When you talk about exemptions, that kind of implies that I have to have a crisis, an issue, a concern, and then I bring that exemption forward and that request to be excluded after the damage, the harm has already been done. We're asking for a proactive measure that gets out ahead of the issues that really creates safe spaces for our educators to work. So in my head, this is the difference between being ahead of the problem and reacting to a problem. So I think that our request to be included in this measure really is about getting ahead of and preventing the concerns, as opposed to always reacting and waiting till there's a crisis to have a response.
Thank you so much.
Thank you very much. Any other questions for Katie? Seeing none. Katie, get back to it then down there. Thank you so much for your time today.
Appreciate it. Thank you all.
Sure. Next on the agenda, we have Carl Jacobson. I see him online. Carl, please carry on.
Good afternoon. Chairs Gadkar Wilcox and Datham, ranking members Sampson and Carney, and the distinguished members of the Government Oversight Committee. My name is Carl Jacobson. I am the Chief of Police for the New Haven, Connecticut. I am here representing the Chief Connecticut Police Chiefs Association that represents the interests of all the police chiefs in the state. Collectively, the members of the association oversee the operation of over 7,000 law enforcement personnel and close to 100 law enforcement agencies. CPCA would like to offer a position on the following piece of legislation, SB 973, an act concerning redaction fees for the disclosure of records created by police body-worn recording equipment or dashboard cameras under the Freedom of Information Act. One of the primary reasons that we come before you today is to request your assistance in providing an avenue that enables police departments to continue to provide the public and interested parties with information and videos that are not exempt from disclosure, while also providing agencies with a fee structure that does not currently exist for video. CPCA has supported the wholesome implementation of body cam and in-car cameras for Connecticut's law enforcement community, as it provides transparency, accurate and independent evidence of many aspects of investigative efforts, while also demonstrating the professional efforts of officers. However, while agencies have long been able to charge for written public records under FOIA, there is no such provision for agencies to charge fees for the considerable time and effort to reproduce, redact, and furnish requesters with digital media. In the case of the body-worn and in-camera recording, some agencies have to hire additional staff in order to address this new requirement. Other departments may use existing sworn or civilian staff who dedicate countless hours to review, redact, and copy digital media. For example, a simple video that in short duration with little or no redactions may take an hour or two to review, redact, and reproduce into a disk or thumb drive to provide to a requester. On the other hand, an incident that has multiple recordings from several officers and contains images that are required to be redacted may take 16 to 20 hours or more of staff time for it to be suitable for release. In addition, with the rapid increase in this technology, there are often additional features, equipment, and costs in the department have to invest to reproduce this material, that there is no way of these costs to be offset by reasonable fees. To give the committee a glimpse of what agencies are experiencing in terms of volume of workload for this footage. In New Haven, for example, we have 15 full-time civilians, 2 sergeants, and a lieutenant who oversee the redaction of body camera and dash camera. With all these employees of this agency working on the redactions, they are still months behind of the volume of requests and the workload that it takes to review and redact all the footage. New Britain Police Department has 3 detectives, 1 officer, and a sergeant that are all working on the FOIA request for body and dash camera footage. These are just 2 examples of what agencies are dealing with across the state. This bill will help to change the current practice and will help to strike the balance between providing the public the information they want from law enforcement agencies while establishing a fee structure that helps public agencies offset the rapidly increasing costs associated with this technology. And I just wanted to add on a personal level related to the viewing of body camera. If we are able to get some fees produced, things we would use them for are not only the equipment and to pay the people to do it. These people who look at this, the civilian staff, the officers, are reliving these incidents. And in New Haven, it could be a homicide, a shooting. It could be a child that's been abused. They're reliving these incidents over and over again. So in my department, and most of the other chiefs agree with me, the mental health and wellness of our employees is crucial. So we would also have these fees to offset costs to care for our people better. So that is our presentation, and I appreciate your time.
Thank you very much. I appreciate that, Chief. About how many requests does New Haven get for body camera video under FOIA currently on average?
I'm sorry, I don't have the exact number, but I would say at least 50 to 60 a month.
Wow. And so each of these 50 to 60 a month, you said, they can be fairly quick or can take 16 to 20 hours if it had multiple issues. About what % of the requests you have are greater than just that are more complex in nature?
Well, I would say in New Haven, we run about 65 to 70% with the larger, because in the when a major incident happens or something happens where an arrest is involved, there's numerous officers working. So you're going to immediately have maybe 5 cruisers and 10 officers show up. Each one of those body cameras needs to be reviewed from every angle, redacted, looked through before the video is put out. So that's really where the work is. If it was just one specific angle in one car, great. But in an agency like mine, where the responses are larger than usual, but I would say also a smaller agency that doesn't have 15 record clerks also runs into the same problems.
That's really helpful. You'd mentioned that you're part of the CT Police Chiefs Association. Is there any sort of national organization of police chiefs that some of your members might be a part of?
Yes, there is. And I believe that organization as well is supporting some type of fees. I think it's important. I in reading the proposed bill that some of the video is free, right? If somebody's directly involved in it, if they're an attorney. So there'll still be a lot of instances where people will be able to get this video for free. And I believe the first 4 hours of any request is free. After that, there would be fees. So I think we're really being reasonable. I know that nationally there are other states that allow, and maybe they allow too much, right? Too much charging. But I still think Connecticut is a great place, and we're transparent, and our policing is great, and we need to continue to have a healthy balance, and that this bill does that.
Great. You actually answered my question preemptively. So I'm going to have a look at some of these other states as well for our research here. But I appreciate you testifying that. Are there any questions from the committee? Okay, Representative Gucker.
Good afternoon, Chief, and thank you for testifying. My question is quite simple. Do you feel that once we establish or put in place a fee structure for this, that it might actually cut down on the amount of FOIs that you would receive asking for this type of information?
Yeah, and we have a lot of important FOIs, right? Whether it be the media that wants to put out a story, a victim, a suspect, a lawyer. Those are all important. But we also have people who just put in FOIs for every major incident in the city, whether they want to just look at it, whatever they want to do with it, whether they're looking for police mistakes, whatever they might want to do with it. And I think that it will definitely, I'm not saying 50%, but maybe 20 or 30% reduce some of the fishing expeditions that we see from people in the community that are just looking for certain things. Now, if they have a client who is a victim or a suspect, then yes, they'll be able to still get it for free. So I think that's important. But I would say the direct answer is yes, we will see a decrease.
Thank you, Representative.
And if I could follow up, I would tend to believe as well, I do have friends and family who are on the job. And I understand that we are dealing with some shortages of manpower, but also being able to get officers out there with what they really need to be doing. I'm not saying this is not important, but I thank you for that answer. I would feel that, if we did put this fee structure in place, in your words, I think it would also help with some of those fishing expeditions that are taking, I believe, valuable resources away from other work officers can be doing. Thank you very much for your testimony.
Yeah, thank you for saying that. I have 2 sergeants and a lieutenant. When I first took over chief 2.5 years ago, I said, do we really need that? Because I wasn't familiar with it. Then I saw the workload and what is really a part of it. And I do need those officers there, but I'd rather have them somewhere else.
Thank you very much. We have a question from our good co-chair.
Thank you so much, Madam Chair. Thank you, Chief, for being here. And I should start by saying I'm a faculty member at Quinnipiac University, and we have Chief Reyes with us, who's former chief of police there and doing a great job on campus. I just wanted to follow up on the point about how this impacts perhaps different types of districts. Does it impact districts similarly, whether they're smaller or larger police precincts, urban, suburban context, large cities, small suburbs? Is there a kind of similar impact? I mean, I heard you say for New Haven, there's months delay, but if you can just talk about sort of the impact on maybe other smaller districts as well, and what are you seeing sort of across the state in terms of the impact of this?
First of all, thanks for noting that. Chief Reyes made me assistant chief years ago and started me on this journey. So tell him I said hello. And yeah, I mean, it doesn't matter where you go, right? We think about size, right? So I have 400 officers, but the agency that has 25 officers is still going to need to take 2 or 3 officers, a small percentage, but still a percentage of their workforce to do this work, right? So if there's less requests or the requests are fed through with a small fee, I think it's going to help lessen the load on those departments. And when I say, you know, we have 10 officers respond, North Branford might have 4 officers respond. That's still 4 times the number of hours. So say it's a 3-hour incident. That's still 12 hours of video that has to be looked through slowly, like in real time. You can't fast forward through it. So there's still 12 hours for that agency to look through. So I think it affects us all. In speaking with my other members of the CPCA, it didn't matter what size department you were, you still had a percentage of your workforce working on this.
Thank you so much.
Thank you very much. I have one question that came up whilst you were talking. With your national organization, are there any sort of mechanisms in place that people will know the cost of the request as they submit it? Or how is that sort of calculated so people know in advance and they don't get
I
sticker?
was thinking about that too. I think the bill kind of leaves that open-ended, comparable to what it costs us. So I think it's really gone down to setting up a reasonable hourly charge, and then sticking by it. The organization I'm talking about is the International Association of Police Chiefs. I will do some more digging into that, what they're requesting. They are also saying there should be a reasonable fee, right? But attached to these. But you know, like I said, in some areas of the country, it's unreasonable and more of a deterrent, so people won't ask for it. And we don't want that. We want to stay accountable.
Yeah, I think that's important so people know in advance and then don't make the request and then all of a sudden get in a situation.
Yeah,
Another,
and ours will go through a portal, so we'll be able to tell them the cost prior to them processing it. So
and just to confirm, do people put a credit card down as they make these sort of payments, or how does the payment work for some of these other police organizations?
yeah, I believe it is all web-based, so it will be a credit card type thing. Of course, we're not charging now, so we don't have a mechanism right now.
Right, so that would be an additional administrative burden because presumably the police department doesn't take other sort of payments for things, might have to go through like a town portal, and we'd have to kind of have towns would have to figure that out and the cost
Yeah.
associated with that. So I think there's a little bit of sort of definite thought we have to kind of put in here because I did notice that the bill was sort of open about capping fees, and it capped hourly rates, but didn't cap the sort of number of hours. And that didn't seem like there was any sort of correlation between the type of request and how much it could be. So, but I appreciate that, and we will look into some of these other organizations and find out a little bit more about how these work. Seeing no other questions, thank you very much, Mr. Jacobson.
Thank you.
I'm going to call to see if Ms. Korea Brown is online, or is she in the room? Oh, here she is. Please state your name, and you have 3 minutes.
Thank you. My name is Evelise Correa Brown. I'd like to thank the committee for allowing me to speak today. I'm speaking on two bills. First, I do support SB 1209, an act prohibiting the disclosure of the address of public school teachers under FOIA. It is hard enough to retain teachers, especially because they have the potential to make more as bartenders. Let's keep them and their families safe, especially in this climate. Next, I am opposed to the fee structure in SB 973. There's no option for low-income customers or an option for a fee waiver, putting over police communities at even greater risk for abuse, injustice, and the usual civil rights violations. Not everyone can afford a lawyer. I've been parts of actions where police went as far as to lie on reports, and the police body camera video resulted in the arrest for hate crime charges. The average police tank costs a department about $200,000 a year. This isn't a doctor's office who has to hire additional staff for pre-authorizations. It is a taxpayer-funded agency with bloated budgets that should be subject to auditing, especially as the need for police reform is seen with every new viral video from body cameras now worn. Thank you.
Thank you so much. You know, you do raise a good point about low income families, and I appreciate the comment. I did want to point out that the bill that we have here does have exceptions. So people who are victims or the parents of a victim would be able to get this without any sort of fees. So when you're talking about other people that might need to request this and you're concerned about the low income, are you thinking of other people?
Yes, I am thinking about other people. I've had to there was once where there was a family afraid to come forward because police hadn't arrested the man. So me and my friends, we put in the request ourselves for Enfield Police. And the man had admitted to threatening to shoot a 14-year-old that was fundraising for a football team. It was then where the man was arrested because the video did go viral on TikTok. And there was so much that was going on with that family due to police harassment. They ended up moving out of state. But it did result in a hate crime arrest, but there just are certain instances where police misconduct is obvious and people sometimes are afraid to come forward or hold police accountable, but they should be subject to audit.
Thank you.
And is there also an exception for media in there? Because I didn't see that.
There's an attorney exceptions are involved person in the record requested, the parent or legal guardian of an involved person, or an attorney representing an involved person.
I'd also like to mention that maybe there should be an exception for media, especially because they're not these rich, bloated entities that we see anymore. So the average reporter, you know, they'll have to go to their editor and stuff. I mean, the Hartford Courant's making cutbacks, CT Insiders, you know, merging with a whole bunch of different people. So local print happens to be struggling with money. So that's something also I'd like to suggest.
Thank you very much. Any, Representative Gucker.
I'm just gonna turn it this way for you. This side of the room is all G's. Real quick, just what would you consider your definition of media? Because I do have in my district some people that are not really with any kind of organized media, but they call themselves media because they just do an online presence. I mean, would there be an exception for that to where I have noticed with some of that, there has been some FOI abuse that's happened because they're looking for something that may or may not be there. I'm not, you know, degrading what's going on, just to kind of clarify what that would be so that we kind of get a fair balance for all.
I would guess the requirements are you have to state the outlet that you're with because people claim that they're citizen journalists all the time and they're so annoying. So I get what you're saying. I guess there would have to be some sort of requirement such as a website, the outlet itself. Most people won't go as far as even posting an online blog that do this irritating stuff. So maybe the requirement being like an official website for their outlet, because someone like Kevin Brookman is technically a citizen journalist. And his blog is pretty reputable when it comes to things with Hartford police. And then there's other people that just have like a Twitter, and they tweet their releases on Twitter. So even that additional hurdle requiring a website, whatever that may be for their outlet, would cut out a lot of FOIA abuse, because anyone can claim to be media, but it's going to be hard to wade through most of the citizen journalists, but you can get rid of like 90% of them by having a website requirement. Or something else like, how often do your editions print? Like, is it monthly? So if people can go back like that, then.
Okay, Representative Gucker.
Thank you, Madam Chair, and I appreciate that clarity. We do have, we do have some people that are citizen journalists, but they also do have a website. They do have, Facebook presence. But most times I interpreted a journalist to be moreover of looking at all sides and coming to a conclusion. And sadly, we have in this day and age with access to computers, right in your hand with your phone. You have people that claim to be journalists, but yet they have their journalism, moreover, seems to just expand their preconceived idea of making things fit their own narrative. And I would like to see it more be that you're presenting a question, you're presenting possible evidence, and you're presenting some sort of some answer. And I would just be concerned that if we don't narrow down what actually is considered the media, that we don't run into abuse. I mean, I firmly follow what you're saying with access, especially dealing with, those who can't afford. I've dealt with many people that have been afraid to step up because of threats, because of issues that happen. And, I hope that those people, still are able to come forward with some safety and those tools that they need. But at the same time, I would like to also kind of pare down some of the abuse for people's personal gain for some end that really doesn't suit the purpose of what we really should be looking at. So
Oh, thank you. I wouldn't consider Facebook as someone's platform for journalism. I mean, people post stuff all the time there to get monetized. So like with me, I get paid per click. So I do earn money off my Facebook page. But even then, I wouldn't consider myself to be like a reputable news outlet. I would think that having a higher standard, such as a website and, an outlet, maybe some sort of registered something. What is the tax ID for the whatever it is, adding those additional requirements for media would help. Someone from the Hartford Courant would have a much easier time than someone from around the corner who wants to audit absolutely everything because whatever thing on Reddit told them to.
Thank you. Anything else, Representative?
I just wanted to thank you for that clarity, and I would look forward to more, outreach on that and more clarity, because I do think with what we have going on in society, a lot of the needs for some of these protections, not necessarily with what you're discussing right now with the body cameras, but we're also discussing, protections for teachers and first responders and other things with FOIA, to where a lot of this is driven online by people who profess to be activists or media. And look, I'm an activist as well on many issues. But at the same time, we want to try to protect those people from the unintended consequences that come from people that, you know, sometimes may not look at what they perceive to be journalism to actually be in the worst case propaganda that just drives further hate and further division. And then, of course, people acting out irrationally. And then we wind up with safety issues and problems. So I thank you for your testimony. I thank you for your clarifying that. And I would look forward to following up with you on maybe defining what actually media is and how do we maybe put in some of those safeguards so that we don't have to look at doing FOIA exceptions to protect people. Thank you.
Great. Thank you, Senator Gadcock Wilcox.
Thank you so much. And thank you for your testimony, having this committee sort of focus on what other exemptions perhaps would be helpful as part of this bill. So when, and particularly when it comes to vulnerable communities. So would an exemption just based on the testimony you provided that you had to provide or file a claim on behalf of someone else, would sort of an extension to say an individual or someone filing on behalf of the individual, would that be helpful? I mean, what kinds of exemptions were you thinking?
Oh, sorry. While it would be helpful, there, even then that might need some clarity because it's still able to be abused in some of the manner that Rep. Gucker spoke about. But I guess having some sort of direct affiliation, that requirement, just not like something saying citizen journalist, having there be a reason besides, oh, it's the First Amendment. Because yeah, technically it is the First Amendment, and then you can just pay the additional fees. But I guess it would have to be, I'm the case manager handling this. I'm the something. There has to be some sort of direct affiliation. But having it just be by blood may be problematic. So maybe representative of the family. I don't know.
Yes, we can consider that, but appreciate your comments.
Thank you for that. Seeing no other questions or comments, thank you so much for your testimony today. Hope you have a good day.
You too. Thank you.
Last call for James Murray. Okay. Is there anybody else in the room or on Zoom that would like to testify today? Seeing no others, I think we can close this public hearing. Any objections to closing the public hearing? Seeing no objections, we'll close the public hearing. We will be having a committee meeting following a 5-minute recess.